Good afternoon, everybody. Dr. Mahavir Singh, sir, can we begin with the program, or else we should wait for 3 minutes?
Good afternoon, everyone. Sir, actually, Anmol is seeking permission. With your permission, can we start the program or shall we wait for another 2-3 minutes and let everybody?
Okay, go ahead, please. Go ahead.
Okay. Means Anmol, you can start the program.
All right. Good afternoon, everyone, and we warmly welcome you all to this special occasion of celebration of the Golden Jubilee of the Law Center 2. We thank you all for joining for this webinar. I am Anmol Kulhari, a first-year student at the Law Center 2, and I am the student coordinator for today's session. Just a little housekeeping before we start with the session. If anyone has any questions or queries during the course of the webinar, please type out or comment them in the chat box of your Google Meet interface. We will bring them up after the lecture and end the question answer sessions at the end. Now, I would like to request Professor Mahavir Singh Kelo, sir, Professor in Charge, Law Center 2, to welcome our today's distinguished speaker, Honorable Mr. Sudhir Kumar Jain, Judge, Delhi High Court.
Thank you, Anmol. Honorable, respected, distinguished, our guest, Justice Dr. Sudhir Kumar Jain ji, Professor Kiran Gupta ji, and other my esteemed colleagues and dear students present here for this webinar on judicial response to triple talaq. Very, very good afternoon to you all. I'm sure that all of you know to that fact that gold has been the standard of exemplary purity and excellence since time immemorial. And I'm happy, very happy to be part of this milestone of Law Center 2 for the celebration of its Golden Jubilee. Law Center 2 is celebrating its Golden Jubilee year 2021-22. We have already successfully organized number of programs, events, and activities, and we are on our way to create a road map for the future generation. In continuance of celebrating of Golden Jubilee year, Golden Jubilee year of Law Center 2, today we are adding one more event in our Golden Jubilee celebration. Regarding Law Center 2, as all of you know, Law Center 2 has a long, proud, and distinctive history. It is one of the distinct centers of Faculty of Law, University of Delhi. Law Center 2 was founded in the year of 1971 at the premises of ARSD College, Talaq, to provide quality education while offering full-time course, LLB course. Today, Law Center 2 is a Golden Jubilee Center 2021-22, continues to be a progressive center and made a strategic commitment to the higher quality of teaching and research. It is a premier institution and is known for its qualitative teaching, research, and other co-curricular and extracurricular activities. The center is a hub of research and learning for law students. To promote students' activities at the center, a number of committees have been constituted, like moot court committee, debate committee, seminar committee, journal committee, Legal Aid Committee, Placement Committee, and Alumni Committee. The center had the privilege of being headed by the top law scholars of India, such as Professor Upendra Bakshi, Padam Shri awardee, a well-known jurist and former Vice Chancellor of University of Delhi, Professor Tahir Mahmood, who subsequently became a chairperson, Minority Commission, Professor A.K. Cole, who was elevated as Vice Chancellor, NLU Jodhpur and NLU Ranchi, Professor Gurdeep Singh Bahari, who became the Vice Chancellor, NLU Lucknow, Professor B.T. Cole served as chairperson, Delhi Judicial Academy. Professor Poonam Saxena is presently Vice Chancellor, NLU Jodhpur. Law Center 2 has the privilege of having alumni from all walks of life. As Law Center 2 is celebrating 50 years of teaching, the center has grown exponentially in footprint, academic offerings, and student body. Today, number of alumni of Law Center 2 are contributing in the future of India. The alumni included senior bureaucrats, police officers, revenue officers, doctors, engineers, chartered accountants, company secretaries, politicians, etc. Some of its alumni includes His Excellency Honorable Governor of Arunachal Pradesh, Brigadier B.D. Misraji, Sri K.J. Alphonse, Member Rajya Sabha, Ex-Minister of State for Tourism, Justice B.D. Ahmed, Justice Kailash Gambhir, Justice S.N. Dhingra, Justice Radhi Sankdar, Justice V.K. Rao, Mr. M. Damodaran, Mr. G.D. Gaya, Mr. Manoj Kumar Sinha, Director, Indian Law Institute, New Delhi, among many more legal luminaries. Law Center 2 has been publishing two journals named National Capital Law Journal and Journal of Contemporary Law, publishing quality research papers in the field of law and contemporary issue. I feel proud to be currently associated with Law Center 2. My dear students, colleagues, and non-teaching staff, everyone associated with Law Center 2, we cross the zigzag path of thousands through mile and tenicities, and today it is a time to celebrate, to introspect, and to consolidate, and to plan for Law Center 2 future. Today, we have an event on the topic judicial response on triple talaq. We have our distinguished guest, Honorable Justice Dr. Sudhir Kumar Jain ji. As all of you know, that he is one of the eminent personality in Indian legal fraternity. Justice Sudhir Kumar Jain, born on 10th of November 1962, did his LLB, LLM, PhD from Law Faculty, University of Delhi. Practiced as an advocate in Delhi District Court, High Court of Delhi, served as a lecturer of law in Campus Law Center, Delhi University, before joining judicial services. Joined as Delhi Judicial Services in the year of 1992 and promoted in Delhi Higher Judicial Services in the year of 2003. Posted and worked in different jurisdictions such as civil, criminal, rent, CBI, etc. editor of Indian Report, ILR, Indian Report, Delhi series, posted as principal district and session judge in Sadras and Northeast District, Delhi. Posted as principal district and session judge, come special judge of Prevention of Corruption Act, CBI at the House and Avenue District Court. Posted as joint director, additional director, and director, Delhi Judicial Academy. Served as judge in charge of Delhi Mediation Center, Tis Hazari Courts, and Rohini Courts. He was a member of Academic Council, National Judicial Academy, Bhopal. Dr. Justice Jain ji was regular resource person in National Judicial Academy and other academics in the states and district legal authorities, law colleges, schools, and institutions. He has been wrote many articles on administrative law, mediation, and on other legal issues. He is a trained mediator and trainer for mediator with national recognition. Received 10 hours training on concept and techniques of mediation in year of 2005 from experts from Institute to Study Development in Legal System, California. He has been received a training of trainers from experts from Center for Effective Dispute Resolution, United Kingdom. Conducted mediation in about 2,000 cases of all categories with experience of more than 2,000 hours in conduction of mediation. He conducted more than 100 training programs throughout the India mediation for judicial officers, advocates, law students, etc. Participated as a speaker in various regional, national, and international conference on mediation. Accredited mediator by International Mediation Institute, Holland. He was elevated as permanent judge of Delhi High Court on 28th February 2022. I salute, sir, and I warmly welcome you at our Law Center too. And we are good fortunate that we are having such, scholar and eminent legal luminaries at our center. And I not only hope, but I'm sure that our students, our teachers will be benefited from your scholarship. And I again salute and welcome you, sir, at our center. And kindly now over to Sita or Anmol.
Thank you so much, sir. I just want to add something what Mahavir Kalon sir had just said. Sir have been so kind to us, and of course our beloved professor in charge, he has been always a guiding force to us, and Professor Kiran Gupta too. Well, sir, I would like to add something about Sudhir Kumar Jain, sir. Is above all, whatever you have told about him, he's such a great human being. I have been knowing him from last 15 years or so. He's such a great human being, a teacher, and I would like to say about him that he's such a grounded person. Whenever I met him, I never felt like that I'm meeting someone from judiciary. I always felt that I'm meeting someone from the faculty, and that is his. I would like to say that this is something what best part I have seen, like in his, whenever I have met him. So now, Anmol, please carry on. And I just want to say something that what the students may not be knowing. Sir has already told that he was one of the faculty member of. He had taught for some good time at Campus Law Center also, and you will get the same taste as a teacher is speaking between you with all of us. You will not feel like that someone from judiciary is talking, and someone you will not feel someone some from such great heights a person has come between us to talk with. He will come on the same footing as we are today. So this is now I request Anmol, please carry on the program. Thank you.
Thank you, Shikha ma'am. Thank you, Mahavir sir, for the welcome address. Now, moving forward, I would request Professor Dr. Kiran Gupta ma'am to give us an insight into today's session. Over to you, Kiran.
A very okay. Thank you, Anmol. A very good afternoon to all of you. Professor Mahavir Singh has already welcomed our guest today, but I just want to tell his achievement in one word, one sentence. He is a student of law. He is a teacher of law. He is a trainer of law. He is a practitioner of law, and he is an interpreter of law. And as Shika has said that she knows him for the last 15 years, I can say that I know him for the last 38 years. And to me, I just can't call him Honorable Justice Sudhir Kumar Jain. He is my younger brother. For me, he is Sudhir. And that's all. Since I have been given the task, even though all the things will be covered by Sudhir in his talk, since I have been given the task to introduce the topic which we are going to discuss today, uh, as we know, all of us know this fact that Islamic jurisprudence has developed from four roots. There are four sources of Islamic law: Quran, Hadith, Ijma, and Qiyas. As far as India is concerned, till date, major part of the Muslim law is uncodified. It started from the British period that no codification has to be done. We have a statute, Muslim Personal Law Shariat Application Act 1937. Instead of codifying the Muslim law, what this act says is that all Muslims in India, whether born as Muslim or converted to Muslim, Islam religion, they in personal law matters, which include marriage, divorce, maintenance, talaq, and other forms of dissolution of marriage and succession, etc., will be governed by Sharia. And Sharia means the law, which, or you can say the practices, binding practices, which have originated from Quran, Hadith, Ijma, or Qiyas. If we look at the marriage, though marriage in Islam is a civil contract and not a sacrament, unlike in Hindu law, yet Islam, like any other legal system, insists upon subsistence of a marriage and prescribe that breach of marriage contract should be avoided as far as possible. Marriage remains a simple procedure compared with divorce, so much so that a complete chapter is devoted to talaq and another on its details. Prophet Muhammad himself declared that among the things which has been permitted by law, divorce is the most detestable. Prophet Muhammad did not like pronouncement of talaq, though it is permitted in Islam. The idea behind this is to preserve, so far as possible, the sanctity of marriage, thus holding talaq an evil, a sin. Permitted, but it is an evil in the eyes of religion. In spite of the sacredness of the character of the marriage, Islam recognized the necessity in exceptional circumstances of keeping the way open for the dissolution of the marriage. As in the opinion of Islam, it is better to allow the parties to get separated than compel them to live together in an atmosphere of hatred and disaffection. The basis of divorce in Islam is the inability of the spouses to live together rather than any specific cause on account of which the parties cannot live together. Muslim marriage is a contract and stipulations therein are enforceable, however, with the caveat that they must not be unreasonable or against the public policies. Muslim law permits prenatal agreements, prenatal stipulations. The Quran, we will found in Quran chapters on divorce, especially chapter 2, chapter 4, and chapter uh, 65 led essential conditions and procedure for divorce. A divorce may be either by the act of the husband or by the act of the wife or by their mutual consent. As per Islam, there is no need of intervention of any judicial or administrative authority for getting out of a dead marriage. And Islam permits giving of talaq extrajudicially. And this extrajudicial divorce can be either pronounced by the husband. Some right is given also to the wife to seek dissolution of marriage without the intervention of court. And by mutual consent, of course, they can get it dissolved. And if they dissolve their marriage by mutual consent, it is called mubarak. But if we actually look at the practical aspects, and even in theory also, the right of a Muslim husband to get out of the marital union, to break the marriage, is much, much more than the right of a Muslim female. A Muslim female can seek dissolution of marriage if the power to pronounce the talaq is delegated to her by the husband conditionally or unconditionally, temporarily or permanently. This is called talaq tafweed. If this power is delegated, then she can get out of that marriage by pronouncing talaq on behalf of the husband. Or she can seek khula, which is basically requesting the husband to untie the knot of marriage on giving something in return to the husband by the wife. Except these two, plus if it is by mubarak, by mutual consent, then she will be a consenting party to it. She has no other right to pronounce to get out of the marriage. But husband's power to pronounce talaq, though talaq is not favored by Prophet Muhammad, it is not encouraged by anywhere by the Quranic verses, still by practice, it has become very common. The right of the husband to pronounce talaq to the wife is much, much more than the right of the wife to get out of the marriage. And as far as pronouncement of talaq is concerned, Muslim law provides two forms of talaq, talaq-sunnat and talaq-biddat. Again, sunnat is of two kinds, talaq-hasan and talaq-hasan. Talaq-biddat is basically, as far as talaq-sunnat and sunnat, which includes talaq-hasan and hasan is concerned, by the discourse of Sudhir, we will come to know that they are not so much objectionable. But as far as talaq-biddat is concerned, it resulted in automatic dissolution, immediate dissolution of marriage. Once it is pronounced, it is irrevocable and parties cannot marry again unless there is an intervening marriage, which is called halala, and which require that marriage has to be solemnized with another person. The wife has to marry some other person. The marriage must be consummated and it must come to an end either by pronouncement of talaq or by the death of the second husband. Then only she is now legal or available for marriage to the first husband who has already pronounced three talaqs to him. And though it was not a practice which it is in the eyes of theology, it is a sin. This form of talaq is sin, but it has become the most favorable, or you can say most used form of talaq by the Muslims, especially in India, because no intervention of any authority is required. Anytime the Muslim can pronounce talaq, without keeping in mind that for pronouncement of that talaq also there are so many restriction and a detailed procedure prescribed in Sunnah itself. It cannot just like be pronounced talaq, talaq, talaq. So, but the court, unfortunately, our courts have started treating mere pronouncement of three talaqs as resulting in talaq, even though in Sunni law it is pronounced in anger or due to some intoxication or to satisfy the wishes of the parents or due to any other reason, and the person may repent his action in pronouncing that divorce, but still the wife is not legal for him. So all these practices started, and it has created a chaos in the Islamic society. Unfortunately, the courts accepted this practice, but fortunately, for the last 30 years, the court are not accepting this mere pronouncement of three talaqs without any reason, without reconciliation, or mere plea, taking the plea that I have pronounced three talaqs to this lady and she is not my wife, as not amounting to talaq. And this is what my brother Sudhir is going to explain to all of us. So we are giving you a very difficult task, Sudhir. So please satisfy us and our students. Yes. So Anmol, now the floor is yours, and you now invite our guest for the discourse.
Thank you for the in-depth insights to the topic, Kiran ma'am. I'm very sure that everybody is looking forward to the session. Now, without further ado, I would now request the distinguished speaker for today's session, Honorable Justice Mr. Sudhir Kumar Jain, to kindly present the lecture on today's subject matter, which is judicial response to triple talaq. Sir, now over to you.
Thank you, Anmol, for giving me this opportunity. Good afternoon to all. First, I would like to congratulate the Law Center 2 for Golden Jubilee celebration. I have been the part of Campus Law Center since 1983, having very cherished memories attached with the Campus Law Center and law faculty. As Dr. Mahavir Singh mentioned, that I did my law, LLM, PhD, thereafter a short period, a teaching for short period, and thereafter I also remain attached. Still, I'm very well connected with the Campus Law Center 1, as well as Law Center in all the law faculty. Law faculty, you know, is having a permanent place in my heart and soul. So I can never be detached from law faculty. Dr. Mahavir Singh, Professor in charge, Law Center 2, my esteemed and well-respected sister, Professor Kiran Gupta, who is the program director, and Madam Shikha Kambos, who is the program coordinator for Golden Jubilee celebration, other faculty members, and my dear students. It's really a great opportunity for me to be the part of this Golden Jubilee celebration as one of the speakers on the topic. I really feel myself very honored and privileged. And Professor Kiran Gupta rightly mentioned, I am always for her is Sudhir, not Justice Sudhir Kumar Jain. She is my, not like, but she is my real elder sister. She know me when even I did not join the law.
No.
I was the part of my BSc course in Hansraj College. So what I could achieve, my achievements, as mentioned by Dr. Mahavir Singh, are totally witnessed by Madam Kiran Gupta. So I always very fortunate to have her blessings always in my career on every field, whether it is a family or it is my social, professional, or whatever may be my achievement. Thanks. So, मैं तो I cannot say Professor Kiran Gupta. I'm
Yeah.
though
No need to say that.
for the sake of formality, I'm calling her Dr. Kiran Gupta, but in fact, she's my
No,
real
no,
elder
no
sister.
need to be
Thank you all.
formal. No need to be formal.
No, I'm not formal at all,
Yeah.
or I cannot be formal with you
Yeah.
at any time in any capacity. I am totally informal with you. As
But
sir,
जो ना formal or informal is to be happened in the society, not in vacuum. It is the part of your students. Formality, informality is to be happened in the society.
very definitely, sir.
That is part and parcel of the society.
Formality sometimes
Family
is the
members can't
hallmark
be
of
formal.
authenticity.
Family members can't be formal.
Yes, definitely. So today we are discussing very important topic, the judicial responses to the idea of triple talaq. As Madam Kiran Gupta has mentioned about the source, Islamic source of law, which she has mentioned four sources of law, different kind of talaq and divorce which are prevailing, which are in practice by the Islamic community under the Islam. We know the background. About 2-3 years back, the idea of triple talaq among the Muslims under the Islamic law, that is Shariat, it was a very well debated in media, academically, among the students, law scholars, politicians, and everywhere else. It is a general perception that before that judgment which was delivered by the Honorable Supreme Court in the year 2019 in very famous case, Saira Banu case, there was no judicial pronouncement on this issue. But it is not like that. You know, I was holding the family court in Delhi district in for 3 years. I came across many civil suits where the husband had shot the declaration that his marriage be declared be declared as dissolved on the why, because he has already pronounced the divorce by giving triple talaq, by pronouncing talaq, talaq, talaq. In many cases, it was issue before me. What is the idea of marriage, why divorce, and how this idea of triple talaq, that is talaq with that which Madam Kiran Gupta had just mentioned, how it was accepted by the court, different high courts, even before the independence by the Privy Council. On this issue, I will be presenting a very short PowerPoint presentation, because it's very difficult to remember all cases with their citation and what was observed by the Supreme Court and different High Court. This slideshow is visible on the screen. Hello?
Yeah.
Yes.
Yeah, it is visible.
If you find in our society, traditional, whatever may be the religion we are following, marriage is always considered as an institution of trust, tolerance, and mutual understanding. In our society, matrimonial relationship demands mutual trust, regard, love, and affection, with reasonable adjustment between the spouses. You know, we are the part of a very vibrant society. Conflicts are bound to be there. Every day we are facing the conflicts or dispute in our life. So in the matrimonial relationship, husband and the wife, it is not always there that they should agree on each and every issue. As I have just mentioned, like in the society, the conflicts in the marital relationship are also normal and well expected. You will find that marital conflict not confined to difference of opinion, rather it may be a series of poorly handled events which deeply damage the marital relationship. A divorce, if you define the divorce, a divorce terminates the marital relationship or bonds of matrimony between the married couple. But it has to be, if you notice in Hindu Marriage Act 1955 and after enactment of Hindu Family Courts Act 1984,
A definite procedure is prescribed for Hindus, Jains, Sikhs, Buddhists, how to take or divorce or how to dissolve their marriage. But in Muslim, as I am coming directly to the triple talaq, that is talaq-e biddat, the Hanifi school supported the practice of talaq-e biddat amongst the Sunni Muslims in India for many, many centuries. This is affected by one definite pronouncement of talaq, such as I talaq you irrevocably, or three simultaneously pronouncement like talaq, talaq, talaq. These pronouncements are uttered at the same time simultaneously. It is it is like an instant talaq which is irrevocable, as the madam has mentioned. It is irrevocable at that very moment when it is pronounced. But many countries, those who are following the Islamic culture, Islamic tradition, they have already abolished the talaq-e biddat, and these countries can be very well divided into three heads, like Arab states, Southeast Asian states, and continental states. Arab states such as Algeria, Egypt, Iraq, Jordan, Kuwait, Lebanon, Libya, Morocco, Sudan, Syria, Tunisia, United Arab Emirates, Yemen, and Southeast Asian states like Indonesia, Malaysia, Philippines, and our subcontinental states such as Pakistan, Bangladesh, Sri Lanka have already abolished talaq-e biddat by suitable legislation. But in India, it was in practice, it was being followed in the Sunni Muslims under those who are having the faith in Hanifi school. But the problem which came before me when I was holding the court as a principal judge, family court in North West District, Rohini courts. One petition was pending before me. The facts of those cases that the plaintiff and defendant, they got married according to Muslim rites and customs in the presence of two witnesses. Nikah was executed and read by Qazi, but gradually temperamental differences between plaintiff and defendant surfaced. Although there is a chain of facts, but those facts are not relevant for the purpose of this deliberation. The plaintiff pronounced talaq, talaq, talaq in presence of two persons. Thereafter, he filed a suit for declaration and prayed for passing a decree of declaration regarding the dissolution of marriage between him and the wife, that is defendant, that he has already pronounced triple talaq in the presence of two witnesses. Issue before me whether the marriage was validly dissolved between the plaintiff and defendant. And this case gave me an opportunity to go through the judicial pronouncement by different high courts, by the Supreme Court, and by the Privy Council also. The most important thing related to this case was that it was filed before the pronouncement of the Act of 2019, but I decided this case after the promulgation of Act of 2019. Dear friends, you know, the courts in India, pre-independent and post-independent, in many occasions discuss the validity of talaq-e biddat. Initially, the Privy Council in the year 1932, in a very famous case, it is referred by many high courts and Supreme Court in their judgment, Rashid Ahmed versus Anisha Khatun. This is citation is AIR 1932, Privy Council 25. In this case, the Privy Council adjudicated the issue pertaining to the validity of talaq-e biddat. It was pronounced by a Sunni Mohammedan of the Hanifi school to his wife. In this case, the husband pronounced triple talaq in the presence of witnesses, but in the absence of wife who received dower. Most important thing which was attached to this case is that the husband and wife, even after the pronouncement of talaq-e biddat, they continue to live together, cohabited together for a period of more than 15 years. Ultimately, the wife challenged the validity of divorce on the grounds that she was not present at the time of pronouncement of the divorce. And secondly, after the pronouncement, cohabitation and continued, and the relationship subsisted for a further period of 15 years till the death of husband and 5 children were born. But even then, the Privy Council observed and upheld Talaq-e-Biddat triple talaq pronounced by the husband as valid even in the absence and without the knowledge of the wife, and particularly after taking into the consideration the husband and wife, they continue to cohabit together for a long period of 15 years. Indirectly and directly, the Privy Council in the year 1932 held the validity of the Talaq-e-Biddat in the Rashid Khan judgment. And thereafter, the Guwahati High Court, a single judge, thereafter a division bench, considered the validity of Talaq-e-Biddat. They moved further. It's a very famous case. It is again referred in the Saira Banu case and Samira Banu case, which I will, Samim Ara case, which I will be referring after some time. In Ziauddin Ahmad versus Anwara Begum, it's a 1981 1 Guwahati Law Reports 358. It's a single bench judgment. The wife claimed maintenance, but her claim was contested by the husband before the High Court of Guwahati High Court, on the ground that he had divorced the wife by pronouncing divorce by adopting the procedure of Talaq-e-Biddat. In this case, for the first time, after 1932 judgment, the validity of Talaq-e-Biddat was examined. The Guwahati High Court in this case concluded that the talaq must be for a reasonable cause. First thing which was for the validity of a Talaq-e-Biddat was given by the Guwahati High Court, but it should be for a reasonable cause and must be preceded by attempt of reconciliation between husband and wife by 2 arbiters. What does it mean? That before a husband expresses intention to pronounce Talaq-e-Biddat, it must be preceded by or succeeded by reconciliation efforts by 2 arbiters, one from the family of the wife and another should be from the family of husband. If the reconciliation is failed between husband and wife, only in that event the talaq can be affected. The High Court concluded that the petitioner had merely alleged that he had pronounced talaq, but did not establish the factum of divorce by adducing cogent evidence. It means that no evidence were adduced by the husband before the trial court, before the High Court, that he has made the efforts for reconciliation and divorce was intended to be given for a reasonable cause. In this case, the High Court upheld the order awarding the maintenance to the wife and also concluded that the marriage between the parties was still subsisting. So, Guwahati High Court, in this Ziauddin Ahmad case, did not accept the pronouncement of triple talaq, Talaq-e-Biddat, by the husband to the wife in the absence of conciliation efforts to be made before the pronouncement of Talaq-e-Biddat. Again, Rukia Khatun versus Abdul Khalik Lashkar, it is again 1981 case, but this judgment was delivered by a division bench. The one judge was the common in previous case as well as in the Ziauddin case as well as in Rukia Khatun case. I think Justice Baharul Islam, who became also the judge of the Supreme Court, again in this case, the wife moved an application for grant of maintenance under section 125 of the Code of Criminal Procedure, which was rejected by the subdivisional judicial magistrate. The wife challenged the order before the Guwahati High Court. The claim was contested by the husband by asserting that he had divorced by way of Talaq-e-Biddat and executed a Talaq-nama. Again, the validity of the divorce pronounced by the husband by way of Talaq-e-Biddat and wife's entitlement to the maintenance came up for consideration. Again, the Guwahati High Court concluded that the talaq must be for a reasonable cause and must be preceded by an attempt of reconciliation between husband and wife by 2 arbiters. As the same view which was taken in the Ziauddin case by the Guwahati High Court, it was affirmed by the division bench in Rukia Khatun case. So in 1932, the Privy Council considered uh, upheld the validity of the Talaq-e-Biddat even after the 15 years of continuous habitation after the pronouncement of the Talaq. But a departure was made by the Guwahati High Court in Ziauddin case in Rukia Khatun. First, the husband need to establish reasonable cause and reconciliation efforts by two members, two arbiters, before the pronouncement of Talaq-e-Biddat. Now, in Delhi High Court also, this issue was considered in detail in year 2008 as Professor Dr. Mahavir Singh mentioned the name of Justice Badr Ahmed. This judgment was also delivered by Honorable Mr. Justice B.D. Ahmed, Masroor Ahmed versus State, 2008. In this case, as usual, there was a discord between the couple. The husband pronounced Talaq-e-Biddat. The wife alleged that she later came to know that the husband had divorced her by exercising his right of Talaq-e-Biddat. All the issues before the court, they were crystallized in different issues, but I am referring only the three issues, leaving aside the other issues. What is the legality and effect of a triple talaq? You know, all these judicial consideration, they are happening before the promulgation of Act of 2019 and that Saira Bano judgment also. What is the legality? Does a talaq given in anger result in dissolution of marriage, as Professor Kiran Gupta just mentioned? Sometimes the talaq is given in a heat of anger, under intoxication, by family pressure. There may be the multiple reasons why a husband pronounced the talaq-e-biddat to the wife. And what is the effect of non-communication of the talaq to the wife? Say, elaborate discussion was made about the validity of Talaq-e-Biddat and the important paragraphs of 26 and 27 of the judgment. And this is the entire Islamic jurisprudence on Talaq-e-Biddat was referred and mentioned by the court, by the honorable judge. What is mentioned? It is accepted by all schools of law that Talaq-e-Biddat is sinful. As the Dr. Kiran Gupta also mentioned, Prophet Muhammad was also not in favor of talaq, divorce. It was taken as a last resort. Many guidelines, many other ways are prescribed under the Islamic jurisprudence, which are required to be followed before the pronouncement of the talaq. But some schools, I have mentioned Hanifi school, regarded it as valid. The courts in India also held it to be valid. I mentioned the judgment of 1932, Rashid Ahmed. The expression bad in theology but valid in law is often used in this context. But the honorable judge observed the fact remains that it is considered to be sinful. It was deprecated by Prophet Muhammad. It is definitely not recommended or even approved by any school. It is not even considered to be a valid divorce by Shia school. In Shia school, unlike the Sunni school, it is not recognized. There are views even amongst the Sunni schools that triple talaq pronounced in one go would not be regarded as three talaq, but only as one. In this case, the simultaneous pronouncement of triple talaq was taken as one pronouncement, not the three pronouncement done simultaneously. The court took the judicial notice. What is that? The judicial notice can be taken of the fact that harsh abruptness of the talaq has brought about extreme misery to the divorced woman. How? The social factor after the pronouncement of the triple talaq was considered by the court. Even to the men who are left with no chance to undo the wrong or any scope to bring about a reconciliation, as Madam Kiran Gupta has mentioned about the halala, the procedure of halala. It is an innovation which may have served a purpose at a particular point of time in history. In past time, it may be relevant, but in the present context, this Talaq-e-Biddat has lost its relevancy, what is observed by the Delhi High Court. But if it is rooted out, such a move would not be contrary to any basic tenet of Islam or the Quran. You know, the Madam Kiran Gupta has mentioned the four source of law in the Islamic jurisprudence, but the main source of law in the Islamic jurisprudence is the Quran, Holy Quran. All the other four sources, they are complementary to the Quran. They do not over, they are not having any override effect over the Holy Quran or any ruling of the Prophet Muhammad. Again, in paragraph number 27 of the judgment, the Honorable Judge observed, I would hold that a triple talaq, even for a Sunni Muslim, be regarded as one revocable talaq. It is not the continuous three triple was talaq, talaq, talaq. It was considered as one revocable talaq. This would enable the husband, why? The reason, this would enable the husband to have time to think and to have ample opportunity to revoke, and same during the iddat period. All this while family members of the spouse could take sincere efforts at bringing about a reconciliation. Even the court has thought about the reconciliation after the pronouncement of triple talaq by taking it as one revocable talaq. Moreover, if that period expired, the talaq can no longer be revoked. As a consequence, the estranged couple still has an opportunity to enter matrimony, just mentioned. So a perusal of the conclusion recorded by the Delhi High Court reveals that the triple talaq pronounced at the same time is to be treated as a single pronouncement of divorce and as a single pronouncement, and therefore severing matrimonial ties. Finally, the husband would have to complete the prescribed procedure. You will find after going to this all judicial pronouncement that there is a detailed procedure is prescribed in case of talaq-e-biddat that the Guwahati High Court has considered. It must be for a valid reason, a reasonable cause, and must be preceded by conciliation efforts, at least by two arbiters. Now, again, the Kerala High Court in 2017, since 1932, and in its journey, the judicial pronouncement in journey from 1932 till 2017 and 2019, they again and again, they deprecated the practice of divorce by giving divorce by following talaq-e-biddat. Again, in this case, Nazir versus Shamima, again the Kerala High Court examined the validity of talaq-e-biddat and considered the two judgments of the Guwahati High Court besides other High Court judgment. The Kerala High Court again deprecated the practice of talaq-e-biddat and called upon the legislature to codify the law. As the Madam Kiran Gupta has just mentioned, that in most of the Islamic jurisprudence, the law is not codified, although some efforts are made by the legislature to codify, like Shariat Act of 1939, Dissolution of Muslim Marriages Act 1939, and this Act, Protection of Muslim Marriages Act, this is after this in 2019. But still, the Muslim personal law is governed by the uncodified law. The Kerala High Court, I remember the speaking through the Honorable Justice Mr. Muhammad Mustar, stress upon the codification of this issue, the talaq-e-biddat. What was observed? This case only symptomized the harsh realities encountered by women. You know how the courts were sensitive about the harsh realities faced by other problems, social, economical, family problem, other bad times faced by the women belonging to the Muslim community. The courts were very, very sensitive about these issues. This case only symptomized the harsh realities encountered by women belonging to the Muslim community, especially of the lower strata. It is a reminder to the court, unless the plight of the sufferer is elevated in a large scheme through legislation by the state, justice will be a distant dream reflecting the promise of justice by the state, equality before the law. How the courts, they deprecated the practice of talaq-e-biddat by connecting it with the equality before the law. It's a real justice if we want to give to the marginalized section of the society, particularly the lower strata of the society, emphasis was laid to codify this law. The state is constitutionally bound and committed to respect and promise of the dignity and equality before the law. How the dignity of a woman was discussed by the Kerala High Court. It cannot shrink its responsibility by remaining mute spectator. The Kerala High Court came down heavily on the state agencies by not making a suitable legislation which govern the different aspect of Talaq-e-Biddat. Malady suffered by the Muslim women in the name of religion, and their inexorable quest for justice broke all the covenants of the divine law. They profess to denigrate the believer and the faithful. See how the Kerala High Court was tough in the word, in its word when it came to the plight of the woman, particularly the lower strata of the society, and when the equality before law was negated to the affected women. Now coming to the very famous case, as we know, Saira Banu versus Union of India and others. Why I referred the cases before the Saira Banu cases to just highlight and one issue that it is not that in 2017 the Supreme Court in Saira Banu versus Union of India discussed the validity of Talaq-e-Biddat. Before that also, the Supreme Court as well as the different high courts and Privy Council, they have already discussed the validity of Talaq-e-Biddat in much detail. What had happened in this case, Saira Banu case? The petitioner sought a declaration that a Talaq-e-Biddat pronounced by the husband to be declared as void ab initio. It's a petition was filed by a wife. She contended that such a divorce which abruptly, unilaterally, and irrevocably terminates the ties of matrimony, purportedly under Section 2 of the Muslim Personal Law Shariat Application Act, which is now commonly known as Shariat Act, be declared unconstitutional, and it is not a part of Shariat Muslim Personal Law. By Shariat Act, what was made, the personal law, uncodified law, was made applicable to govern the different aspect of the Islamic jurisprudence. It was further pleaded before the Honorable Supreme Court that divorce of instant nature cannot be treated as rule of decision under the Shariat Act. The practice of Talaq-e-Biddat is violative of fundamental rights. In this case, the Talaq-e-Biddat has taken a wider perspective. It's a wider spectrum. It was tested on the touchstone of fundamental rights which are guaranteed to every citizen in India under Articles 14, 15, and 21 of the Constitution. It was further argued that the practice of Talaq-e-Biddat cannot be protected under the rights guaranteed to the religious denominations under Article 25, 26, 29 of the Constitution. And the practice of Talaq-e-Biddat is denounced internationally. I have mentioned large number of countries, the Islamic countries, they have already denounced the practice of Talaq-e-Biddat. And a large number of Muslim theocratic countries have forbidden the practice of Talaq-e-Biddat. As such, same cannot be considered. It was argued forcefully, it cannot be considered sacrosanct to the tenets of Muslim religion. But in this case, a 5 judges bench was divided. The judgment was delivered by majority of 3:2. But the two honorable judges, although they gave their decision in favor of Talaq-e-Biddat, but they again command the state legislature, parliament, to enact a suitable legislation within a period of 6 months. Now, Honorable Mr. Justice Jagdish Singh Kehar, his lordship was Chief Justice of India at that time, and Honorable Mr. Justice S. Abdul Nazir, in their judgment, laid emphasis about the need to determine the legal sanctity of Talaq-e-Biddat. That is, triple talaq through express legislation, the Muslim Personal Law Shariat Application Act 1937, I just mentioned, commonly known as Shariat Act, in contrast to the rival claim that talaq is having stature of personal law and the Talaq-e-Biddat has a constitutional protection as per the Shariat Act. Their lordship observed that the judgment in the Rashid Ahmad was rendered on the incorrect understanding of the Muslim personal law, Sharia, and needs to be examined afresh. You will notice one thing: the judgment delivered by the Privy Council in Rashid Ahmad case was not very well appreciated by the superior courts in India post-independent. The different approved practices of the talaq amongst the Muslim have their origin in hadith and other sources of Muslim jurisprudence, and merely because it is not expressly provided for or approved by the Quran cannot be a valid justification. You know, as the Madam Kiran Gupta has mentioned, that it is talaq is not a welcome step in Islamic jurisprudence, but the honorable two judges mentioned merely because it is not expressly provided for or approved by the Quran cannot be a valid justification for setting aside the practice. The court observed in favor of observation of talaq-e-biddat. It was further observed the practice of talaq-e-biddat is in vogue since more than 1400 years, and talaq-e-biddat, though bad in theology, as I just mentioned, was considered as good in law. It was further observed that Shami Mara case, that I will refer afterwards. This was a judgment delivered before the case of Saira Bano. Shami Mara case did not debate the issue of validity of talaq-e-biddat, as no submissions have been noticed for or against the proposition. And any observation made in the Shami Mara case was considered not to be treated or taken as ratio decidendi in the matter regarding the validity of triple talaq. You know, their lordship further observed that the practice of talaq-e-biddat was considered to be the religious denomination in question. Sunnis belonging to the Hanifi school, their lordship observed that the practice of talaq-e-biddat is a part of personal law. Personal law has a constitutional protection through Article 25 of Constitution as fundamental right. And this was argued by the petitioner in Saira Bano case that the practice of talaq-e-biddat cannot be protected under Article 25 of the Constitution. Their lordship did not accept that the question subject covered by the Muslim personal law Shariat application ceases to be the personal law and got transferred into the statutory law, and held that the practices of the Muslim personal law Shariat cannot be required to satisfy the provisions contained in Part 3. Very important observation in favor of talaq-e-biddat, that the wires of Shariat law cannot be tested in context of the Part 3 of the Constitution, which deals with the fundamental rights. The provisions of Shariat Act did not alter the personal law status of the Muslim personal law Shariat. Their lordship further did not accept that the practice of talaq-e-biddat can be set aside and held as unsustainable in law for three defined purposes expressed in Article 25(1), that is, for reason of its being contrary to public order, morality and health, and has no nexus with morality and personal law. So this two judges, honorable judges of the Supreme Court, they spoke in favor of talaq-e-biddat. They mentioned that it is not violating the fundamental right as enshrined in the Part 3 of the Constitution. And the practice of talaq-e-biddat as violative of concept of the constitutional morality. Even the idea of constitutional morality was discussed, but it was not accepted by Honorable Mr. Justice J.S. Keher and Justice Nazir. However, they issued following direction. In view of the position expressed above, we are satisfied where a present situation where this court should exercise a discretion. The direction were issued to the state under Article 142 of the Constitution. Union of India was directed to consider appropriate legislation, particularly with reference to talaq-e-biddat. The directions were given to the Union of India to draft or enact suitable legislation, particularly to cover the talaq-e-biddat. And what was given by the honorable two judges, till such time as legislation in the matter is considered, we are satisfying the practice of talaq-e-biddat was injected for a period of 6 months. and the Union of India was directed to draft or enact a suitable legislation. If the legislation process commences before the expiry of period of 6 months and a positive decision emerges toward defining talaq-e-biddat as one, or alternatively, if it is decided that the practice of talaq-e-biddat be done away with altogether, the injunction would continue. And a very particular directions were given कि inject this practice of talaq-e-biddat for a period of 6 months. In the meantime, enact a suitable legislation. If suitable legislation is enacted, it is come into the force, the injunction would continue. Otherwise, it would cease to operate. It would vacate automatically without further extension. So this was the proposition on talaq-e-biddat was given by the Honorable two judges, Justice J.S. Keher and Justice Nazir. But Honorable Justice Korean Joseph has taken different view. The Korean Joseph relied upon this Samim Ara versus State of UP and another. It's a 2002 judgment, 7 SCC 518. His Lordship highlighted the Section 2 of the Muslim Personal Law Shariat Application Act, and very important observation was made by Justice Korean that observed that after the 1937 Act, law which is applicable to Muslims in respect to the marriage, dissolution of marriage, including talaq, shall only be their personal law, namely Shariat. It was mentioned, but simultaneously what was mentioned by Justice Korean Joseph, that Section 2 of the Shariat Act does not regulate talaq. Although it covers the talaq, but no measures are taken in this act to regulate the various aspects of talaq. His Lordship further observed that the Holy Quran has attributed sanctity and permanence to matrimony, as Madam Professor Kiran Gupta has mentioned, but in extremely unavoidable situation or circumstances, talaq is permissible. But an attempt for reconciliation, as observed by the Guwahati High Courts, in just I referred two cases, if it is succeed, then revocation are the Quranic essential steps before talaq attains finality. Before a talaq, particularly talaq-e-biddat, attain its finality, the efforts of reconciliations are required to be made. In triple talaq, this order is closed. Hence, triple talaq is against the basic tenets of the Holy Quran, and consequently, it's violates Shariat. Because there is no scope for reconciliation, that's why it was taken as not in accordance with the Shariat, or and it's violate Shariat. His Lordship observed that the above view was endorsed by the High Court and finally by the Shamimara. Honorable Mr. Justice J.S. Keher and Honorable Mr. Justice Abdul Nazir did not rely upon Shamimara. They said only observations were made which cannot be taken or treated as issue decidendi. But the Justice Korean Joseph mentioned that Shamimara can be taken as a law which ban or banning the triple talaq also. In this case also, the Supreme Court has referred, Justice Joseph referred Shamimara, where it was referred that there are no reasonable substantiated in justification of talaq, and no clear proof that any effort at conciliation preceded the talaq. The talaq must be for a reasonable cause. Remember the Guwahati High Court, two cases, and be preceded by attempt at reconciliation between the husband and wife by two arbiters. Again, a judgment from the Andhra Pradesh High Court was referred, Jamrood Begum versus K. Muhammad Hanif and another. Similar view was expert. Even the High Court of Jammu and Kashmir and Kerala in different cases, Manzoor Ahmad Khan versus Saza, 2010 judgment. Again, the reliance was placed on Shamimara case. The Jammu and Kashmir High Court observed that the Shamimara, in this case, the apex court relied upon the passage from the judgment of various high court, which are eye-opener for those who think that Muslim can divorce his wife merely at whim or on caprice. See how the High Court of Jammu and Kashmir came down heavily on the practice of triple talaq, by after following Shami Mara case. And these are the judgment they were delivered before Saira Banu's judgment in 2017. The High Court of Kerala in Nazir versus Shamima, also just I referred above, also referred the Shami Mara case and disapproved the practice of triple talaq. His lordship did not agree with the view that practice of triple talaq has to be considered integral to the religious denomination in question, and same is the part of their personal law. Now, very important part of the judgment was delivered by Honorable Mr. Justice R.F. Nariman and Honorable Mr. Justice U.U. Lalit. Their lordship, they again relied on the Shamim Ara and denounced the judgment and did not in agreement the judgment. Just I referred the judgment delivered by the Privy Council in Rashid Ahmed case. Honorable Mr. Justice U. Lalit and Justice Nariman, what they opined and held that the triple talaq is instant and irrevocable as reconciliation between the husband and wife by two arbiters from their family, which is essential to save the matter, cannot ever take place. And what is required to be preceded before triple talaq is that reconciliation. Their lordship did not agree with the view expressed by the Privy Council Rashid Ahmed that the triple talaq is valid even it is not for a reasonable cause. They observed that it is not longer holds good after Shami Mara case, which I referred. It is clear that this form of talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation. This form of talaq must therefore be held to be violative of fundamental right. Justice Nariman and Justice Lalit, they denounced and deprecated the practice of triple talaq by connecting as it is violative of fundamental rights as contained under Article 14 of the Constitution of India. How this judicial determination on triple talaq has taken its course. Although Justice Keher and Justice Nazir, they upheld the validity of the triple talaq, but simultaneously they injected and stopped this practice for a period of 6 months till the time is suitable legislation is drafted or enacted by the Union of India. Justice Korean Joseph traced to deprecate the practice of triple talaq from the various judgments previously delivered by various high court and particularly the Shami Mara judgment delivered by the Supreme Court. And then the Justice Nariman and Justice Lalit, they connected the practice of triple talaq as violative of fundamental rights as contained in Article 14, 19 and 21 also. And even after judgment delivered by the Supreme Court in Saira Banu case in 2017, this again many high courts, they again denounced the validity of triple talaq after relying on Saira Banu. The Jammu and Kashmir High Court Srinagar bench in Muzaffar Ahmad Tokar versus Shaina Akhtar and another, it is a judgment delivered in 2018, and another judgment delivered in the month of August 2018, Javed Ahmad Wani alias Waja versus Nagina Akhtar. What is observed that the practice of talaq, triple talaq, has been declared to be void by majority of view in Saira Banu case. The correct law of talaq as ordained by the Holy Quran is that the talaq must be for a reasonable cause and must be preceded by attempt and reconciliation between husband and wife by two arbiters. That the same decision, same guidelines, they are being followed by the different high courts, which were taken in 1981 by the Guwahati High Court in two cases. First by the single judge bench, then thereafter by division bench. And due to the lack of quorum and other reasons, the act could not be passed, and the Lok Sabha after Saira Banu case promulgated Muslim Women Protection of Right of Marriage Ordinance. This, on the basis of this, the Muslim Women Protection of Rights on Marriage Act 2019 was enacted in Delhi High Court. A challenge was made against this ordinance. In the case, the High Court of Delhi, Shahid Azad versus Union of India. It was delivered on 28th of September 2018. The High Court considered the challenge made to the Ordinance 2018. A mandamus was sought to declare the entire ordinance as ultra vires the Constitution on ground that it adversely affects fundamental rights. Besides affecting the rights of citizens of this country, the ordinance runs contrary to the shared belief, practice, and tradition of Islam is discriminatory in nature and therefore should be declared as ultra vires. Again, an attempt was made to declare this ordinance as ultra vires because it is considered to be against and running contrary to the belief, practice, and tradition of Islam. But how the Delhi High Court observed. Once this form of talaq is declared as unconstitutional and impermissible by the Supreme Court, if the government has legislation in its wisdom thought it appropriate to make it such unconstitutional illegal act an offense, we in exercise of extraordinary jurisdiction under Article 2026 of the Constitution cannot declare the law making such an act punishable as ultra vires the Constitution. So, dear friends, see how our Supreme Court has taken this view. Again, in the year 2021, in another case, before the Jammu and Kashmir High Court, the issue was raised whether this Act 2019 Act is applicable to the talaq which were pronounced before this enactment of 2019 or before the pronouncement given by the Supreme Court in 2017 in Saira Bano case. This issue was again discussed by the Jammu and Kashmir High Court in Shaukat Hussain versus Nazia Jilani. It is CRM number 308 2019, and this judgment was delivered on 16th of August 2021. The Jammu and Kashmir High Court, speaking through the Honorable Mr. Justice Sanjeev Kumar, observed that a judgment, if not made to operate prospectively, specifically, is to be treated as retrospective and applicable even to the pending cases. So in this case, the Jammu and Kashmir High Court has observed that this act is having retrospective effect because it is not specifically made prospectively. This was not the intention of the legislature to make it prospectively. So it is equally applicable to the pending cases. What was observed by the Honorable Judge that the Honorable Supreme Court, while declaring the triple talaq as null and void in the eyes of law in case of Saira Bano, did not specifically make the judgment to operate prospectively, and that being the position the law declared by the Honorable Supreme Court in Saira months prior to the passing of maybe the time of pronouncing the triple talaq, particularly in the light of Saira Banu judgment, a majority judgment 3:2. The other, I would like to say it is 5-0 judgment. Although the two judges, Justice Keher and Justice Nazir, they spoke in favor of the following of the practice of talaq-e-biddat, but ultimately in the concluding part of their judgment, they gave the direction to the Union of India to draft to enact a suitable legislation and give an injunction, pass an injunction order on this practice for a period of 6 months. Indirectly, their lordship was also what I consider in my humble assessment and submission, they were also not in favor of following the practice of triple talaq. One judge delivered judgment on the basis of Shami Mara and two judges, they connect it as violative of fundamental rights. How this, the banning of this practice, denouncement of this practice was given different dimensions in different direction by the judicial pronouncement. So in view of this judgment, I in the family court judges passed many judgment dismissing the petitions filed by the husband for declaring the marriage as null and void on the ground of pronouncement of triple talaq. Even on the procedure also, you will find in many triple cases of triple talaq, the procedural requirement of reasonable cause and preceded by reconciliation by two arbiters, one from the husband family and one from the wife family, is not practiced. What is considered is a misconception. It was a misconception that the triple talaq can be pronounced by uttering three words, talaq, talaq, talaq. It was never followed. It was never remained in the valid practice, even by the Hanafi school or by the Sunni law, that segment of the Muslim community. Even before 2017 judgment, even before Shamim Ara 2002 judgment, even before 2019 judgment, what we perceived and conceived that by saying triple talaq, the marriage is over without following and without observing the procedural requirement. So now, should not be considered that before Saira Banu case, our superior courts were not sensitive to this issue. We were very sensitive to this issue. We gave pronouncement right from 1932 to 2021 against the abrupt dissolution of marriage by pronouncing triple talaq. Even the Kerala High Court connected it with the plight of the Muslim woman, particularly belonging to the lower strata of the society, their misery. Even the court also considered the misery of the husband also after pronouncement of that talaq. There is no place of repentance after this triple talaq because we need to follow the procedure of halala. So this immediate instant divorce, irrevocable divorce was not welcomed by the judicial activism, by the judicial pronouncement. Even as per the procedure law, which is being followed under the Islamic jurisprudence. As mentioned and again repeating, no reconciliation, no reasonable cause, only triple talaq, 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 talaq. So that was not accepted by the different high courts, ultimately culminating into the Saira Banu case, before that Shamim Ara case. So this is my little bit was on judicial pronouncement, judicial decisions, the judicial responses in case of triple talaq. I think on triple talaq, our superior courts are now very clear. There is no clouds of confusion, no cloud of ambiguity regarding this. And now, this after Act of 2019, everything is banned, whether reasonable cause, whether reconciliation or not. Now this is completely against the express provisions of law. Many criminal proceedings have been started, cases have been registered on the basis of 2019 Act. So thank you very much for this patient hearing. Thank you.
Thanks, Sudhir. I just want to make one clarification. In Shamim Ara, the court has said not only that there has to be a reasonable cause, there has to be arbitration attempts, but also said that it must be proved that the divorce has been pronounced, talaq has been pronounced.
Yes,
because the practice has started in the Muslim community that whenever a wife comes up with a petition or application for maintenance in the court, husband in the written statement used to plead that I have pronounced talaq to this lady on that and that particular date, some prior date. And she is not my wife now, so I am not entitled, liable to pay maintenance to her. And courts have started accepting pronouncement of talaq at least from the date of filing the written statement. So that practice was also rebutted, deprecated by the Supreme Court in Shamim Ara, that you just can't plead and say that the marriage has dissolved. You have to prove that if you are saying that you have pronounced talaq on 10th of January 2010, you have to prove that you have pronounced it. Just you pleading in the written statement that you have already pronounced talaq on 10th January 2010, it will not result in dissolution of marriage.
When
You
I
have to
was
pronounce and
definitely,
prove.
it
Yeah.
was when I was holding the family courts. So
Yeah.
I also came across many petition under section 125 CRPC. The
And,
maintenance is claimed by a woman, a Muslim woman,
and
and
husband
immediately a
definitely
defense is used to be put forward. I
that
have already divorced the wife.
yeah.
Three, this triple talaq.
Yeah.
But now the approach of the court ki first to grant interim maintenance,
Yeah.
and then after leading the evidence on thereafter on the merits of the case to decide ki whether the divorce is actually given by the husband or it is taken as a defense by the husband.
Yeah.
So I never accepted written statement as a point that from this point a divorce is given by the husband to the wife. Never. First, pay the maintenance.
Yeah,
Because
Justice Lahoti has specifically mentioned in this Shami Mara case that you cannot just accept the plea of pronouncing talaq.
yes, just my mere pleading ki I have pronounced.
Yeah,
It
it's
has to
not
be
sufficient.
proved.
Yeah,
And every divorce has to be proved as per the law.
yeah,
Even it is as per the custom. You know, in Hindu law, the customary divorce is also recognized.
recognized, but it
when
has
there
to
is
be
a
proved.
petition under section 11 for declaring the marriage void, we ask ki where is the divorce by or divorce of previous dissolution of previous marriage by the agency of the court.
Yeah,
If you are pleading customary divorce, then prove it. It must be specifically pleaded and specifically proved by the parties who is claiming the divorce by customary practice.
yeah, and
what I
and
need
the
to
proof
say-
is quite strict.
कि हमारी जो हाई कोर्ट्स एंड सुप्रीम कोर्ट्स they never
They are,
appreciated the practice of triple talaq.
They acted as the social reformer of Muslim
Reformers.
law.
And it was a very big fallacy that before Saira Banu case, this issue was not considered by the different high courts and the Supreme Court sympathetically. Sympathetically means in accordance with the law and in accordance with the Muslim personal law also.
No, earlier also there are cases like Justice Krishna Iyer in Yusuf Rothan case in 1967 has tried to explain the true Islamic law of divorce. And that has been quoted in almost all the judgments by the Supreme Court,
Yes.
including the Shaira Bano, Sami
Yes.
Mara. In every judgment that you can say discourse of the Muslim personal law on talaq has been quoted by the judges.
You know, that sometimes the quality of the judgment is also affected by the social requirement of that
Yeah,
particular time.
yeah.
What the society is asking for. Like when a gang rape case, that Nirbhaya case was pronounced,
Yeah.
there was lot of voice from the different social organization to make this laws more stringent. Thereafter, the relevant provisions were amended by the legislature,
And later on they were diluted also.
diluted also.
Hmm.
Definitely,
Yeah.
when the law in text is put into the law in action, then we have to redefine many law,
Yeah.
various aspect of the law, and give different interpretation of the law.
Judges
Because one-
have to apply
Yes.
the written law to the practical problem.
Because just by one incident we cannot put all other person into the under a big question mark. But
Yeah.
in case of triple talaq, I think our superior courts has taken a very consistent view,
Yeah.
except 1932 Privy Council Justice Rashid Ahmad judgment.
Rashida.
Thereafter, I could not find any judgment, even by the Kerala High Court, which is dominated by Muslim community, even by the Jammu and Kashmir High Court, which is a state which is dominated by the Muslim community. Even those high courts, they spoke against the following the practice of triple talaq in unqualified manner.
They are very active. These courts, Kerala and Jammu High Court,
Jammu
they
and
are
Kashmir.
very active.
Yes.
Sir, I just want to, know, because you are being in judiciary, and you might have, witnessed few of such cases wherein people are not accepting the judgments. They are still, believing in, and they are being, formulated by a stereotype. People like, for example, if I talk about like few of my students who are coming from villages, I have talked to them with regard to triple talaq judgment. But literally told me that, ma'am, this is something which have been in only talk of the town. It has not reached to the villages yet. People are still doing this.
Definitely, one thing is there. Ki legislature, whether it is parliament or state legislature, we can enact the law. Judiciary wing of the state can give interpretation of the law, but it is to be followed by the public at large. There is no mechanism unless and until it is a punitive law. We can force the person to follow this practice. You know, like in IPC, Indian Penal Code, Section 376 is there since long, but
Yes, sir.
still the rapes are committed in
Yeah.
the society.
Yeah.
302
Two is there.
Sir, it happens not
Who is
only
there
with
very stringent death penalty and
offense. It happens with all
All
kind
the
of
laws.
laws.
All the laws.
Either it is could
Yes.
say Muslim law, or you could say Hindu
Whether
law,
it is
wrong of
whether it
Hindu
is
law,
tax
Muslim
law or IPC or
whatever
whatever
it
it
may be,
is.
there is a
whatever it may be,
it
because
happens
motor
there
is very
is
seamless
gap.
legislation.
There is gap.
Motor Vehicle Act,
Enactment of law and execution of law.
jumping of red
Now,
light is
now
a
you have
punitive
to
provision.
select that who is the executor of law.
That's
You have to
Sir,
see who is the
this is something what I want to know. How
Who
to
the
bridge the
Thanedar?
gap? How this
Who is the
gap
who is
can
the
be bridged?
Thanedar?
you know
Who is the policeman?
using
Who is the
using the
executive
gap.
state?
If you realize one thing, that we an individual, we are victim of two problems, two barriers: strategic barrier and perceptive barrier. Strategic barrier, I must get maximum, and perceptive barrier is I am the best.
Yeah.
So unless and until we are able to overcome this our cognitive or perceptive barrier, ki I am the best,
Yeah,
I
I am
know
the best.
everything. So we cannot achieve the what is intended to be achieved by enacting one particular legislation. You know, we are having symbolic legislation, instrumental legislation, like the 1939 Act, which prohibits the restraint of child marriages Act 1939. Still, we witness large number of child marriages, particularly in the state of Rajasthan on the occasion of Akatis.
Yes.
This act is since 1939. Now we are in 2022. It's 61 and 22, 83 years old legislation. Is still
It became teethless.
how if you remember the
Now do we have
theory of law defined by Professor
Prohibition
Raj.
of Child Marriages Act.
Yes.
We have Prohibition of Child Marriages Act, which
Yeah.
says that a child marriage is a voidable marriage and it can be annulled on a petition filed by
Yes.
a child party to that marriage. Still, child marriages are not restricted.
So there's something
they
what
are still
Professor
going.
Mahavir Singh is
Actually-
saying, na, that this is a
Yeah.
teethless,
और देखिए,
teethless legislation.
Actually,
Marriage
sir,
is
क्या है कि what is
आपको बताऊं?
problem?
No,
It
there
is one-
there are penal provision also. Marriage
It
is
is one
voidable.
kind of
Everything
social
is there.
evil, and social evil
Definitely.
cannot be
Removed
abolished
by law.
overnight.
Yeah.
Even after enactment of law, even after delivering of judgment by the Supreme Court.
और ये देखिए,
No doubt,
let
the
me tell
judgment
you,
of the Supreme Court become the law of the land. But
Section
problem
5
is
of the
there-
Hindu Marriage Act.
problem is there that the lack of
Prohibits-
awareness.
Section
Lack
5
of
of the
awareness.
Hindu Marriage Act, it's make the wise totally wide ab initio the marriage between the prohibited degree and subpoena relationship.
Yeah.
I came across number of cases where two first cousin they perform marriage and then they were standing before the court to declare their marriage as null and void. So if you remember this Professor Hurd's theory, union of primary law and secondary law, law is there, but the violation is also there always.
Yeah.
Whatever may be the violation, even in many countries, the death penalties are prescribed for a minimum offense also. Even then, offenses are being committed in those countries. See, narcotics, this NDPS Act, see the severity of the punishment, but every day we are receiving the charge sheet under NDPS Act.
Yes.
As a session judge, every day I used to conduct trial under Section 302 IPC murder
I can
trial.
literally correlate it with you, sir. Sir, the example you gave about spindas and prohibited degrees, someone from my relatives side only, they got married recently. Both of them are, good professional and they are highly qualified engineers, basically one is working for Google and the other is working for Wipro. I told them that this is not allowed by law. Why don't you go for under Special Marriage Act? Nay, we have got solemnization done in front of 1,000 people. So nobody can challenge it. This is something what I'm talking about, the understanding level of, people who are educated somehow. They may not be educated in the field of law, but
And-
they are educated. They can do a Google search, but they will not,
And Kambos, let me tell you, the violation is more among the educated class.
Yeah.
You will find, see, you see this violation in matrimonial court, what I've experienced in other courts, working in other jurisdiction also, that maintenance is granted.
Yeah.
Husband is well off, is doing, earning excellently, either in a high profile job or in a high profile business, even not ready to pay the maintenance to the wife. Why should I pay? They are violating the order of the court. They are violating the law of the land. Many times you will not witness.
It is very easy to get a maintenance order, but it is very difficult to get maintenance.
Yes.
Execution of the order is very,
Yeah,
very difficult. And we have the
execution petition.
mentality. The moment the law is going to be enacted, we start thinking how to avoid that law, how to violate that law.
And this we need to understand in a wider spectrum.
Yeah.
We follow the democratic form of government. You know, in democratic form of government, there is always a loose form of governance. So violations are bound to be there.
Bound to be there.
Everything we
Loose form of
we
government.
test on the touchstone of part 3 of the Constitution. I'm exercising in a writ jurisdiction nowadays. Every petition under Article 226, violation of fundamental rights. But when this is a dictatorship type of government like China, there is no much violation. Right? So this, it depends upon how the society is progressive. Even we claim we are very progressive society, but even then the violations are more in comparison to the normal standard, normal violation also. Even in the minor offenses, which we like, smoking in the public place is prohibited now. But you will find many persons there. I'm staying in the university area. So I notice every day number of students, whether boys and girls, they are smoking in the open place. How you can say? So in this kind of symbolic legislation, it's very difficult to launch prosecution. But like those who are instrumental enactment like IPC, this is protection of Muslim marriages, this right of Muslims, this is 2019 and other act. The prosecution may be simple, may be required, may be warranted. But what we can do? We can make our efforts. I think the time may come where we will be following the law of the land willingly, not under force or not under any latent effect. Maybe the time may come soon. Otherwise, in a democratic society like India, which is governed under the aegis of written constitution, a vibrant judicial system is there, these things are bound to happen. तो हमें तो इस चीज को देखना है कि कितने प्रोसिक्यूशन हो गए, पॉजिटिव साइड में कितना सजा मिल गया, कितना how many person they have been brought to the law. So that we also need to consider simultaneously, apart from the negative side where there is not observation of the law. So right, sir?
Thank you, sir.
Anmol, any question from students' side?
Yes, ma'am. We have a couple of questions. Also, I would like to open the floor for questions. Just a reminder, everyone, that please type questions in the chat box in your Google Meet interface. All right, so ma'am, we have few questions, and due to time, we could only be able to take 2 or 3 questions. Sir, Sudhir sir, I just wanted to ask you a question that why did India take so much time striking down the practice of triple talaq?
This question is very difficult to answer. जब जागो तभी सवेरा है. It is not that the parliament has taken the considerable time. Although the parliament has enacted this law in the year 2019, but remember one thing, this issue was considered by the Privy Council and subsequently post-independence by the Supreme Court and by the High Court, different High Court, continuously and regularly. It is not that we were not deprecating this practice of triple talaq before 2019. But for the first time, it is enacted by the parliament.
Moreover, sir, it's the Supreme Court also, time to time have indicated or intervened as in case if you are able to recall one landmark judgment, Shabano, although
Yes.
that was related to the maintenance, and because of the that decision, government has to amend the law
Yeah,
because
enact the law. Enact the law.
New
Muslim
legislation
law.
was enacted.
and it was because of the intervention of the court,
Yeah.
and which was crying for that decision was crying for the uniform civil code.
Yes.
And
I just refer the Kerala High Court judgment.
Yeah.
The Kerala High Court mandated the Union of India to enact suitable legislation on this issue
Yeah.
before this Saira Bano case also.
Hmm.
As a judges, we can give the only direction to comply or not to comply. Again, it is in the hand of the Parliament or in the hand of Union of India.
Yeah.
Sir, you rightly mentioned one sentence, and that is very, very relevant in the Indian legal system. Although we are beating the drums of democratic governance, but we are having loose governance because of the democracy only.
This is democracy anywhere is the loose form of governance.
Because we could not forget. We could not forget that the democracy is based on the vote politics.
And of course, the other reason are lack of our resources
Yeah.
and the people we have, overpopulation, lack of resources.
Yeah.
Yes.
Everything can't be managed.
Sir,
Lack of awareness overall.
our society is victim of ignorance.
Ignorance. Yeah.
Victim of ignorance.
Even the qualified, well-educated persons, they are ignored about their constitutional, positive, legal, statutory rights.
Even if they know to get a relief in India, it is not an easy task. Everybody
sit-
can't approach the court.
Sir, if you sit in the writ jurisdiction in High Court, you will find how the administrative authorities, they are exercising the discretion given to them.
Right, sir. Right.
Yeah.
Totally abuse of power, misuse of
Abuse.
power, arbitrary exercise, totally non-application of mind in certain cases.
It is our mentality. We
need to
the
change
moment
our
we
mindset.
get some power,
Outlook.
we think that we have absolute power.
Our mentality, our outlook, our attitude. suffering
Sir,
from
I will give you
various
very simple example. Today, Dr. Mahavir Singh met me, suppose, and I gave a compliment. I gave a compliment to him. कि सर आज आप बहुत अच्छे लग रहे हैं. तो his immediate response would be, क्या आप मुझसे नाराज हैं? Hardly anybody would say कि thanks for your compliment. See the negativity in our mentality,
Yeah.
in our mindset. We are born negative. And this is reflecting in the way of working in our government agencies.
Right, sir.
And so, and now
Actually, we
I
are
am,
competing for the resources now.
yes,
Resources are limited. We are competing with each other for this or that.
madam, देखिए, in every society you will find the sources are limited. What is important, the wise distribution of the resources,
Yeah, that is not there.
the management of
Yeah.
resources also.
We are lacking in that. Totally lacking in that.
And moreover, sir, I think that we follow people like anything, like spiritual leaders or
We-
someone who will stand before us and
we-
like give some good lectures. We'll start following them without believing in that whatever they are speaking is true or not.
You know, we still believe in the procedural justice in place of substantive justice.
Yes, sir.
Suppose if I ask, right, this example I used to give in my training on mediation, an orange is to be divided between two sisters. Immediate response would be 50-50%. So what we have done, 50% justice to one sister, 50% justice to another sister. But if we use answer or we handle this problem more wisely, why you need this orange? One sister may say I need pulp to prepare juice, another sister may say I need peel to prepare some cosmetic product. So one sister can be given pulp, another sister can be given peel. So how the 50% justice can be converted into 100%
100%.
justice? So our thinking is totally based on the logic. We are victim of logical thinking, but now the time has come that we need to develop our lateral thinking also, go beyond the boxes, and because of this we are facing a lot of problems also.
So I can see one more question, like One of my colleague is asking a question, Akash Anandji. He's asking, is there anything in the Hindu marriage and its customs which can be similarly regulated and prohibited by law made by the parliament which has not been dealt with the enactments? Or is in practice even though prohibited by
Hindu
law?
Marriage Act.
Yes, sir.
Lots
he's
of things are there which are prohibited but is still practiced.
You know,
There are
many things, many act you will find even they are prohibited under Hindu Marriage Act, but still they are in practice.
They are in
Like
practice.
child marriages, this is polygamy also,
Yeah.
and the marriages between within the prohibited degree or Sapinda relationship also.
Mm.
Even one thing which I always feel that to take the divorce under Hindu Marriage Act is a very cumbersome process. It may frustrate the whole purpose of the act. Still, we need to make irretrievable ground of divorce as a valid ground of divorce, despite the directions given by the Supreme Court in many cases. Although Section 13B may be taken as a justifying the divorce by mutual ground, it may be taken as whereas the marriage is completely broken down, there is no chance of reconciliation between two spouses. But still, every act after 10 or 15 years, with the change in the perception of the society, particularly these social enactments, they need suitable amendments, suitable changes. But hardly any study is undertaken by either by the Law Commission of India or State Law Commission or by the Government of India to study the impact of this legislation largely on the society. Before Hindu Marriage Act, divorce were not known to the Hindu religion. And this Hindu Marriage Act is totally based on the British concept. We accepted this Anglo-Saxon law in India after independence. Most of our acts, they are based on the British enactments, which we were following pre-independence. So, Madam Compose, we need very comprehensive study to study the impact, even whatever may be the nature of the personal law, whatever maybe you may follow, whether as a personal law, codified law, uncodified law, but we need to make a study in a changing social scenario, the social requirement, social jurisprudence.
So we have one more question. Zubair Ali is asking, is halala marriage is justified in our society as it is much regressive practice for women?
These are the social questions. These questions cannot be answered in a legal or judicial.
Right, sir, right.
These are the practicings followed by. That is for that particular community to ponder over the justification of these kind of practices. Like, in the Hindu community, Sati Partha was in the practice. Yes, polygamy was in the Bahu Vivah jise kehte the, it was in the practice.
Yeah.
But gradually this Sati Partha was prohibited. Hardly there is any case. Now with this Hindu Marriage Act, this polygamy is also prohibited unless and until it is permitted by the local laws or custom. So these are the social questions. These questions are required to be answered by the community itself. Otherwise, nobody can answer.
What the spiritual leaders like whom the people are following, like anything
Yes. But we need to consider that whatever may be the practice, religious practice or social or personal law practice which is being followed in any particular religion, it requires reconsideration after some period of time.
But sir, that social issues and laws are deeply intimated to each other. We can't separate the social issues. We can't, because ultimate society is meant for the law is meant for society.
What I understand, every law has to answer the social requirement, the requirement of the society.
Yeah.
Otherwise, it will not be a practical law.
Obviously, sir. Otherwise, there will be no need of teaching or preaching of sociological school of jurisprudence.
Yes. Every law must fulfill the requirement of the society of that particular time. Right, but you will find abrasions every time, everywhere.
That is always there, and that should be there.
Beginning, just you mentioned one question: why this marriage is there? Few abrasions does not make the law invalid in practical.
Right, sir. That's why we are always talking about the emerging needs of the society, emerging issues of the society, emerging challenges of the society.
Yes.
And law is meant for
Maybe,
all
sir,
these emerging issues,
but
challenges, or
see,
dimensions
kind of
of the
society,
society.
which were we are having pre-independence, at the time of independence, after 10,
Yeah,
15 years of independence, 25, 30 years, and at present now, there is a total change in the perception of the society.
Yeah.
What the society is perceiving and conceiving today is entirely different what the
different.
society used to conceive and perceive before independence or immediately after
Before
independence.
independence, or you could
Even
say,
during the last 10 years,
yeah,
societal
during the
perception has
last 10 years,
totally changed.
totally.
Or,
Total
sir,
changes.
at all humility, at my command, I used to mention in informal talks, our country is not governed by the constitution, but it is governed by the parallel constitution, unwritten constitution.
That's there, but
It is
why we needed the written constitution to control the unwritten constitution? Because this unwritten constitution was,
still, see,
prevailing on the society.
say
We
India
can't
is
say that.
taken, sir, India is taken as presumed to be a social welfare state. But
That
now,
is there, but
but
that
nowadays,
those are
the state has become,
unreasonable. Why
no,
why
sir.
we are you are not discussing this issue of triple talaq? It is because of the social issue. It is because of the
That's why I'm
breach of the
telling you,
fundamental rights,
like,
breach of the constitution.
sir, what I am telling you, as per our preamble, as per our constitution, India is a social democratic country.
Yeah.
But now the state has become the most commercial entity, which is against the socialism. But now,
Yes,
sir,
that's why
whatever may be the problem,
sir,
now the
sir,
society is changing.
that's why people
Now,
are crying also against all
we are,
these commercialized education or etc.
yes, now we are marching towards the change. We are marching
Commercialized
towards the betterment.
medication, commercialized education.
Yes, yes. So, how I perceive the society, it depends upon how I think about the society.
Right, sir.
I just mentioned perceptive or cognitive barrier. So, anything else?
Thank you, sir. Thank you.
I think that's all. Shikha?
Yes,
Yes,
Kiran
ma'am.
ma'am.
Yes, I
So
suppose
as
that
we have,
just one or two questions are also there, but I think that we can take up these
Yeah,
questions
sir.
later on.
I have seen the questions. There will be no answer to that question.
Yes,
Already all are
they are more
answered.
like social
So
factors.
let's finish the session.
Yes, ma'am.
Dekhiye,
Please
one thing
express
is that always remember the questions are guaranteed in the life, but answers are not.
yeah.
Right? So thanks, thanks, Dr. Mahavir Singh. Thanks, Professor
sir.
Kiran Gupta. Thanks, Shikha.
Thank you.
Thanks, Anmol, for giving me this wonderful opportunity to be the part of your Golden Jubilee celebration. Really, I'm feeling very privileged person today. Thank you.
Thank
Thanks
you,
to all.
sir.
And again, good evening.
thank
So I'm permitted to leave.
thank
No, no. Lot of
sir,
thanks.
not yet.
Okay, just
Uh,
madam is giving vote of
Sir,
thanks for me.
now I would like to
Sorry?
request. I would now like to request Ms. Shikha Kamboj ma'am, Assistant Professor, Law Center 2 and today's program coordinator to present vote of thanks.
Honorable Justice Dr. Sudhir Kumar Jain ji, most respected.
Over to you, Shikha ma'am.
Most respected, thank you, Honorable. Most respected, our beloved Professor in charge, Professor Dr. Mahavir Singh Kalan, very dear and most humble Professor Dr. Kiran Gupta ma'am, Program Director, respected seniors, dear colleagues, and above all, my beloved students. I deem it as a great honor to propose vote of thanks, and it has been always great pleasure to see you, sir, here with us, because as I told you that, sir, you are starlet for Faculty of Law, and you have been always so kind to the Faculty of Law. Whenever I have requested you to talk to the students, either in personally or in of official capacity, you have been always so kind to answer the queries of the students, and it's a pleasure indeed for all of us to be with you, to listen to you, the kind of experience, the research work you have done for this topic. It's such a great lecture, and I hope all of the students have been enriched and we have lot of things which we have added. It got added into our knowledge, sir, on this topic. And above all, I would like to thank Professor Mahavir Singh Kalon and Dr. Kiran Gupta ma'am for being the guiding force for this program, and Anmol, she is being such a good comparer for this program today. And to all the senior colleagues, and my dear colleagues, I'm so much thankful to all of you for being with us
Dear
to
students
make
also.
this program a great success. Thank you so much. And
Chitra, dear students also.
yes, sir, I that's why I said my beloved students.
That's okay. Thank you.
Without them, the program cannot be done.
Yeah.
Of course, we are doing these such kind of programs for them only. Yes, sir.
Thanks to Ajay also.
Thank you so much. Thanks to, above all, I would like to thank to Kisle Soni for technical support, and Dr. Ajay Sonawir, who have been always such a supportive colleague to all of us.
Yeah.
Thank you so much. Thank you all of you.
उनको भूल ही जाते हैं, जबकि वो सबसे ज्यादा काम वही करते
नहीं
हैं।
एक्चुअली सर, मैंने ग्रुप में भी मैसेज डाला।
ये अब क्या कि वो हम अपना अधिकार से समझते हैं। चलो भी ठीक
नहीं
है।
सर, ये रिकॉर्डेड हो रहा है लेक्चर। देखो, मैं अब फिर से बोलती हूँ,
नहीं,
आई एम
कोई
सो
नहीं,
मच
कोई
थैंकफुल
नहीं।
टू किसले सोनी, एंड आई एम सो मच थैnkful to Ajay Sonawir sir also for
ठीक है, तो मैडम ने अच्छा किया
providing
आपने।
us technical support for today's
Thanks to Shikha also.
oh,
Yeah.
we are just like family.
Yeah.
You know,
Thank you so much.
All thanks to Sudhir
Thanks,
Kumar
Sudhir.
Jain.